All right, well, good morning, good afternoon, everybody. We really appreciate your attending our webinar. This is the Online Trust Alliance webinar on how the FTC identifies, targets, and tracks companies, learn how to keep off their list. It's being presented by David Zetoony. David is a partner in the law firm of Bryan. He is leader of the firm's global data privacy and security practice. He has extensive experience advising clients on how to comply with state and federal privacy, security, and advertising laws, representing clients before the Federal Trade Commission, and defending national class actions. You may have heard David. He spoke at our data privacy and protection, our data protection and privacy event in New York City, and we're really pleased to have him here. Real quick, Online Trust Alliance, we're a 501c3 charitable nonprofit with the mission to enhance online trust and empower users while promoting innovation. Our goal is to help educate businesses, policymakers, and stakeholders while developing and advancing best practices and tools to enhance the protection of users' security, privacy, and identity. We support collaborative public-private partnerships, benchmark reporting, self-regulation, and data stewardship. And with that, I'll turn it over to you, David.
Thanks, Scott. I appreciate it. So in today's program, we're going to talk about three things, and I put the agenda on the screen. So starting off, just so we're all on the same page, is who, what, where, why of the FTC. Who are they, what do they do, where are they located, and what's their mission, why do they operate? And then second, go more towards the topic of today's program, which is how the FTC identifies enforcement targets, and then really hone in on one of those methods, which is how they use data analytics and how they track companies, and then what you can do as a company to both be aware of what the FTC may be seeing about you from a data standpoint, and then also how you can use that data for your own purposes. So Scott, why don't we move to the next slide?
Yeah, and David, I'm sorry, I just forgot to mention one point to all of our attendees, that you are all, I have you all on mute. If you'd like to ask a question, you can just go into your GoToWebinar control panel. There's a question drop down, and you can just type it in there, and I'll see it, and I'll address it as soon as we can. So again, you'll just have to type it in real quick, and I'll be able to address it. So, yep, go ahead, please proceed, David.
Great. So who, what, where is the FTC? It's a very old federal agency. It was established in 1914. It's an independent agency, and it's structured with a 5-person commission at the top, which is split between the two parties. So you have 3 commissioners who are from the majority party, and then 2 commissioners who are from the minority party. So that's it in terms of its organizational legal structure. What's really important in terms of a takeaway is it's about 1,100 employees, about 650 of them are attorneys. And so conceptualize it as a law firm, a very large law firm, and a law firm that is focused on really 2 areas of law, antitrust and consumer protection, and they do that full time. They have a budget of about $300 million. They bring in probably far in excess of $300 million into revenue into the government as part of their law enforcement initiatives. So it is a very effective agency, a very well-known agency with a very long history in terms of its practice. In terms of the where, it's headquartered in DC, but it has 7 regional offices that are spread around the United States. Most of those regional offices are fairly small, with a handful of employees, 10, 20 employees maybe. In DC is where most of the FTC staff resides. So turning to the why, and Scott, you can go to the next page if you like. The FTC enforces more than 70 laws, and a lot of people are surprised by this. People know generally, if you are familiar with the FTC, if your organization has ever been investigated, or if you have any background in terms of data privacy, data security, or advertising, you may be familiar with the Federal Trade Commission Act, which has a very, very broad and general mandate. It's not a complex statute of 100 pages. Its operative provision is really almost a paragraph. It says that unfair and deceptive acts and practices are prohibited. And it's upon that basis, what is unfair and what is deceptive, that most of the FTC's actions are really based. But beyond the Federal Trade Commission Act, there's 69 other laws that Congress has enacted which give the FTC discrete areas of authority. And so a lot of times companies are a little surprised when they run into an area that the FTC has a huge amount of jurisdiction over, But it might be I want to call it a blip on the screen. It may be a very discrete issue, like canned spam, sending out emails. FTC has jurisdiction over that from Congress or Graham Leach Bliley, dealing with financial institutions. So I threw up about 10 statutes here, which are ones that are more well-known, that get enforced more often than not. And then you can see there's a link at the bottom of the page if anybody's interested in the other 60-plus laws that the FTC has jurisdiction over. But when we talk about consumer protection in the FTC, you can really group all of their jurisdiction, all of their responsibilities into 4 main buckets. They care about data privacy, they care about data security, they care about advertising, and they care about marketing. And when you think about advertising and marketing, because those 2 terms are synonymous to a lot of people, for advertising, think of things like national TV campaigns, online advertising, print advertising, and marketing is more how a company goes about selling its products. So things like telemarketing or using particular techniques to appeal to consumers that may be separate from one individual advertisement or commercial spot. So on the next page, I've listed out here the 4 ways that the FTC traditionally uses to identify its enforcement targets. Independent monitoring of companies, competitor or industry or interest group petitions, media attention, and then data mining. And when we get to data mining, I'm going to talk at length more about that than the rest. But before doing that, I want to go over each of these just so everybody has a starting point in terms of the different ways that the FTC gets information about companies and that spark investigations. So on the next page, I'm delving a little bit more into independent monitoring of companies. There's 2 ways that the FTC goes about doing this. And Scott, you can advance, I think, 1 more. Great. So the first is they have some formal programs where they formally set about monitoring a particular area or industry. One example of this, although there are many, is in the online space for looking at websites that may be violating the Children's Online Privacy Protection Act, or COPPA. The FTC produced a report, a series of them, last year, where they talked about sites that may be violating the law. They sent warning letters to companies that may be violating the law. And how they went about that investigation is really telling. It gives you insight in terms of how they do these formal monitoring programs. They have a mobile computer lab and they have a regular computer lab where they access the internet, but they do it from IP addresses that don't link back to the FTC so that companies aren't aware that they're being monitored. And they systematically design a system for how they want to look at a specific issue. So with regard to children's websites, the staff searched for kids, the words kids, in the Apple App Store and then the Google Marketplace. They got all the results back, and then they looked at 960 apps. And of the 960, they randomly chose 480, so half of them, for a closer review of looking at privacy policies, looking at login procedures, looking at how the app was structured. So a very systematic way of identifying a problem, setting out a way to audit the industry, and then carrying out that audit, and from that, they identified areas where they thought people were out of compliance, they identified issues, and part of that went into generating a report in terms of the industry. Other pieces of that may have gone into investigative targets. If they identify somebody through that process who is clearly not in compliance with the law from their perspective, they may decide to elevate that for enforcement. So that's the informal way, that's the formal way of monitoring. But I put a note here at the bottom, which is don't overlook informal monitoring. And remember that the FTC staff members, commissioners, and relatives of staff members, they're all consumers too. And so by informal monitoring, I mean they interact with the world. They go to malls, they shop online, they buy things, and through that process, they oftentimes come across, as consumers, issues that they think might be problematic from a data privacy, data security, advertising, or marketing standpoint. And those issues can absolutely lead to an investigation within the commission. They bring that back home with them from their personal lives, they bring that into the work life, and they may spark investigations. And I put an example of this on the next page. Do you want to forward to the next one, Scott? So I pulled a few examples, and this is one in which Bryan Cave represented the defendant company, DermaDoctor, and came out about 6 or 7 months ago. So what you see on the left-hand side is an email that was sent out by the company to an email subscription list. And what that ultimately translated to was a complaint brought by the Federal Trade Commission. But the reason the complaint was brought was there was an FTC staff attorney who received this email. She got the email, and there was a piece of advertising, a claim in there that she thought wasn't substantiated. We clearly disagreed with that. We thought it was substantiated. But it was enough that personally, when she got this, she brought it back in and elevated it inside the Bureau of Consumer Protection, which ultimately led to an investigation of the company. So just a case study example of this absolutely does happen. Every time your company sends out an email, when you put information on websites, if you be aware of the fact that if an FTC attorney, of 650 attorneys exist, sees it, or one of their friends sees it, or one of their relatives sees it, and it gets reported back in, that absolutely can lead to the initiation of an investigation. Let's go to the next slide. So if the first way that the FTC identifies targets is from formal investigations or informal investigations of industries, the second way is from petitions. And petitions is kind of a generic word. It can refer to competitor complaint letters, which are confidential. It can refer to sometimes industries or industry associations may do their own analysis of who they think is a good or bad actor in an industry and share that with the FTC. And same with interest groups. Sometimes these are filed publicly, where an interest group may put it on their website, may send it to the press, and sometimes they're filed confidentially, where they ask the FTC to afford it confidential treatment. In either way, though, this information that's collected by a competitor, the industry, or an interest group, and makes its way to the FTC can absolutely turn into an investigation. If you go to the next slide, Scott, you'll see another example of this. So this is a case, again, that happened in the last couple of years, where the Humane Society published a petition. It was an open petition. So it's something they sent to the Federal Trade Commission, but they also posted on their website and made otherwise publicly available, complaining that a series of companies were violating regulations governing how you market fur. And this translated ultimately into 3 complaints that were brought by the Federal Trade Commission. And I put the dates here to give a sense sometimes of the time period in between when something sparks a potential interest at the FTC and when it materializes into something public. And this is one reason why a lot of companies, general counsel and outside counsel, have a hard time understanding where different matters start is because of the time delay. So here you can see there's almost 16 months that passed between when the Humane Society initially published their petition and when the FTC launched complaints against Dr. J's and Eminent and then Neiman Marcus. So something to keep in mind is you have to be aware of the fact that there are competitors in your industry who may send information to the FTC. There's also interest groups that may send information to the FTC. Something else to keep in mind is that while some of those parties may claim confidentiality, others don't. But just because they're not claiming confidentiality doesn't mean that it's easy for you necessarily to find out whether somebody is complaining about your company. It used to be the case about 3 or 4 years ago that the FTC would publish formal petitions that had been filed with it on its website. And there is still a link on their website where they have a list of formal petitions. But you'll see that if you ever go to it, that the last petition filed, I think, was 2011 or 2012, which is very misleading. A lot of companies think if they are monitoring that there's been no other petitions filed with the Federal Trade Commission since 2011, and that's not the case. The Federal Trade Commission has just stopped updating that portion of its website. And so generally they don't add petitions on that portion of the website unless there's some notoriety or some publicity reported from other sources about the petition. So it very well could be that there has been a public petition, which means it is available to the public through Freedom of Information Act request, that's been filed against a certain company, they'll throw Acme Corporation. And you won't see any evidence of that on their website. You won't see any evidence of that online. And you actually have to go to the FTC in a Freedom of Information Act request and ask in order to see the document and know that there's a document there, or do a kind of a fishing expedition to find evidence of the petition. So let's go to the next page. The third way in which the FTC targets companies is from media attention. And I threw up another example here. So if some people may remember this case, but CVS and some of the other pharmacies had an enforcement action against them several years ago over data security issues. And what was happening was some isolated pharmacies were throwing prescriptions away in the dumpster behind the pharmacy. And as a result, if somebody jumped into the dumpster or into the trash can, they could find bottles, they could find old prescription slips that showed the name of a patient, showed what they were getting. And if you know that information, you can probably guess what ailment, what disease they have. So a data security and a data privacy issue. The media was the first one to figure this out. And so there was a series of stories in local media of a reporter going to a local CVS, going into the dumpster behind and digging out these old bottles. And he ran a series of reports on this, which started percolating up, and ultimately, and again, I put the timeline here because I think it's important for people to understand, there was about a 2-year separation from when those reports ran to when the FTC made its announcement of a public complaint. But the FTC noted in its own statements, and I highlighted it here, why it launched the complaint, that there were media reports around the country of this happening that ultimately led to the information being brought to the FTC's attention and the FTC sparking an investigation. So let's go on to the next slide. Here's one more example on the media attention side. February 3rd, 2010, there was an announcement of a security breach, a fairly small one at Ceridian, relating to about 27,000 records from a hacker that had hacked into the system. And you fast forward more than a year again, and you can see the distance, and then you have a complaint from the FTC on the same issue. So again, just another case study, another example of where this does happen, where the media jumps on an issue, and from the media outlet, the FTC reads in the paper, literally, about the issue, and then opens an investigation from there. Next slide. So the fourth way that we're going to talk about, and we're going to spend more time on this one, is data mining. So the FTC maintains a database of consumer complaints. It's actually several databases. One is called Consumer Sentinel. One is the Do Not Call database relating to telemarketing, and then they have an identity theft database as well. Collectively, though, internally that gets referred to at the FTC as Consumer Sentinel, and most of those databases funnel into the same type of engine at the FTC side. These databases were started around 1997, so they've been there for a long time. And what they contain are all the consumer complaints that are submitted to the Federal Trade Commission, either from a consumer picking up the telephone and calling the FTC's hotline, or going to the FTC's website, and they have a wizard on the website that a consumer can enter a complaint about any business in the country. They also collect complaints that aren't submitted to the FTC, and a lot of attorneys who practice before the FTC don't realize this, which is 20 state attorney generals forward their complaints, and they have agreements with the FTC that if a consumer writes to them and complains about a company, they'll send that complaint on to the FTC, so the FTC has a copy. There's 8 other federal agencies that do the same thing. And then there's 100 Better Business Bureaus, so non-government entities, which also do the same thing. So at the end of the day, if you're Acme Corporation, and if you have a consumer that is mad about some issue, and they go to a Better Business Bureau and they file a complaint, and you resolve your issue with a Better Business Bureau, or you kind of go through their mediation procedure, you need to also be aware that that complaint got forwarded to the Federal Trade Commission. And it goes not just that one complaint, but every other complaint that your company has had about it from any other Better Business Bureau, from any other of these 8 federal agencies, or from 20 other state attorney generals, or from the FTC, are all going into the same database, and they all start forming a profile about your company. Now, you may know about a Better Business Bureau complaint, because the Better Business Bureau, their policy is to let companies know when a consumer complains about them. That is not the policy of many federal agencies. It is not the policy of the Federal Trade Commission, and it's not the policy of many or most state attorney generals. So in other words, don't assume that you know how many complaints are about your company that are housed with the FTC. You don't, unless you've gone out and you've made an affirmative effort to try to learn that information. The FTC sits on the biggest collection of all complaints from all sources, and the vast majority of those complaints are things that would not naturally make their way to a company. It's not like you'd be CC'd or you're going to get a copy of it or it's gone through some portal where you've been brought into the loop. But rather, the majority of those are complaints that are made directly with the government and they stay with the government. Now, I said that they've been at this since 1997. Formally, their data retention period is 5 years. Informally, there's a number of situations in which they keep records for a lot longer than 5 years about certain companies. So what that means is that in total, they now have over 25 million consumer complaints that relate to companies all across the country. And Scott, why don't we go to the next slide? So what I've included here is a depiction of how many FTC investigations, either a lawsuit, an informal investigation, but something where they've taken action, enforcement action, relates to these complaints. And you can see it varies over time, but it is always an extremely high amount. So whether it's 70% or you can see it's kind of at some points almost approaching 100%, the vast majority of FTC actions do relate to a target that has already been identified in Consumer Sentinel. The FTC used to, and they may still do, have a publicly announced target that they're trying to reach, which I think was 65%. So that they publicly said, we want at least 65% of all of our investigations to relate to a subject that has been named in Consumer Sentinel, a target. They've always exceeded that, to my knowledge, and not only exceeded that by a small amount, but as you can see from this graph, by a significant amount, that they're usually around the realm of 90%. 9 out of 10 investigations link back to a consumer complaint in this database.
David?
Yeah.
We have a question. Are the complaints in the database subject to FOIA?
It's a great question, and the answer is yes. So they are subject to FOIA, and it's something I'm going to talk about in a few minutes in terms of what we do or what a lot of our clients do in terms of looking at these complaints. What will happen if you submit a FOIA request is you will get the complaints out. The FTC will manually redact some information from all the complaints. So what you're not going to see is the consumer's name. And you're not going to see the consumer's email address and the consumer's telephone number. What you are going to see typically is the subject of the complaint. So you're going to see what the consumer, the subject being who the consumer was complaining about. So again, if it's Acme Corporation, you'll see that a complaint was filed on April 9th, 2015. The complaint relates to Acme Corporation. You'll typically get all of the comments, what we call the free form field, that the consumer wrote. So the substance of what they were complaining about. They may say Acme Corporation has a website that is unsecure and I put in my name and I got somebody else's information out of it and the FTC should investigate this. So that free form writing, you'll see it. If there's any personal information the consumer's thrown in there, like their social security number or credit card number, that'll be redacted. The FTC goes through and takes that out. But what you also see is there's a lot of fields within the database that the FTC codes for. So if a complaint comes directly to the FTC, the person at the FTC, let's say it was a telephone operator, will code certain things like this relates to fraud or this relates to data security. They'll code the industry of Acme. So they may say, Acme is in the retail industry, so that gets coded in. And all of that information comes out in a Freedom of Information Act request. And the only thing that really doesn't is personal information about the complainant. So let me turn to the next slide and go into a little bit more discussion about how the FTC uses Consumer Sentinel, because there are a number of ways. So, and I'm just going to start going through these, and if there's any questions, happy to answer them, because there's really no limit to how you can use this database. Once you're sitting on 25 million records, there's a lot that you can get out of that. But I'll talk about some of the main ways that the FTC does use it. So each month, the FTC's Division of Planning and Information creates what's called a top violators report. And that report ranks the 50 companies with the greatest volume of consumer complaints in that month. The report, and I included on the next slide an example of it so you can get a flavor of what this looks like. Great, so this is small print, but we can always send you a copy of the deck afterwards. So you can see here what's typically on the report is the rank for that month and the rank for the previous month, so they can see if a company is going up or down, the company's name, And then to the right of that, I was talking about these codes. Product service codes is what industry the company's in. And to the right of that is the number of complaints that have been filed in that month. And so you can see here in this list of 1 to 50, the top area, the top file letter would be 8,000, which is through the roof. The lowest number to kind of hit that realm of 50 is 122, which once you start getting into that realm of going between 100 and 122, so you start thinking about people who are not in the top 50, but who might be in the top 100 or top 150 who have the potential of entering that list, it starts getting very large very quickly. But this is the type of report that is generated every month within the FTC and is shared with the attorneys who do enforcement. And so from our standpoint, and from most companies' standpoint, this is not a list you want to be on. This is not you don't get a gold star for being #1 on this list. It's something you want to stay and hope that your company isn't making the list. Let's go to the next page. So number 2, how else does the FTC use Consumer Sentinel? One report that they make is a top violators report, which we just went through and really just looks from an absolute numbers perspective, who does it appear might be the worst violators? The second is what the FTC calls the surge report, and this identifies the companies with the greatest increase or surge in complaint volume. And that may be a company that had 0 complaints in the previous month and now has 20 complaints this month. So not on an absolute level that they have a ton of complaints, but on a relative level, it looks like there's a spike. So there's different ways to read that, but the fear is that the enforcing attorneys at the FTC would read that as this company has just developed a problem or a potential problem that we need to investigate. And Scott, if you go to the next page, I included a sample of what the search report looks like. So you'll see here, again, this is for 1 month, a number of companies listed out. And I'm not going to pick on any particular company, but it includes let's do the Federal Grant Commission. So it's imposter, which equals the government. What they're really complaining about here is that somebody is pretending that they are from the federal government. The number of complaints in 1 month was 19, and then the next month was 46. So from their perspective, absolute numbers, you wouldn't reach the top violators report. If this were a company, and this one is not a company, but if the Federal Grant Commission were a company, this would not hit the biggest issues in the US, but what this does indicate is directionally, trend-wise, something potentially problematic is happening, that somebody is starting to spike, they're starting to surge. And you can see if you just look at the deltas, all of these companies are going from a position of 4 to 67, 5 to 37, 3 to 29, or 3 to 25. So again, something that the FTC looks at internally, and you make their radar when you have these big deltas between months. Let's go to the next slide. So it's not possible to know how often the FTC takes action based just on those 2 reports. And there's other ways, I'm going to talk about those in a second, that the FTC uses the data separate from those 2 reports. There's no published statistic that says, this many companies on those reports have been investigated. On the flip side, though, we've done a lot of research on this side. It's something we've looked at for years in terms of translation of complaint volume into investigations. And what I've put on here as an illustration is if you look at these top 6, these are the top 6 companies that had the most complaints over a 4 or 5 year period. Everything highlighted in orange, the FTC took action. It doesn't mean that the FTC brought an investigation against the company, and the first one is a great example. Publishers Clearinghouse Imposters had nothing to do with Publishers Clearinghouse. It had to do with other companies and individuals that were basically doing identity theft on Publishers Clearinghouse. They were pretending to be calling from Publishers Clearinghouse, calling to individuals, and then scamming the individuals. So the action the FTC took was to do consumer education. They issued a press release. They warned consumers about this. They tried to get the message out. On the flip side, you can see T-Mobile, DirecTV, Verizon Wireless, 3 companies that have all received FTC investigations, some resulting in $90 million of consumer redress. So these are very large investigations, all of which were on the top violators reports in terms of volume of complaints against the company. So not a big, we never know what's going through the minds of enforcers, but not a big stretch to see how this happened, that a company is hitting the top violators report. It potentially triggers within the FTC a deep review in terms of what's going on at the company to see if there is problematic behavior. And in these three instances, the FTC determined that there was problematic behavior from its viewpoint and started an investigation in all three cases that led, or two of those cases that led to an enforcement action. One of the cases, Verizon, it actually led to the closure of the investigation. So, the takeaway from there is if the consumer complaints did spark the investigation, it's not a done deal that you've actually done something wrong. And we'll talk about this in a second. There's a lot of reasons why you might have consumer complaints about you, but you have no law violation. And the message there is to prepare yourself that if the FTC asks about that you have a good response ahead of time. It's a way that we proactively position our clients to defend FTC investigations by not being surprised when they come, that we understand what the FTC is saying, we understand the visibility, and we can start designing a defense and designing an explanation before we get an inquiry letter from the FTC. Interesting to note, the one company here that is not in orange that the FTC didn't investigate is outside the FTC's jurisdiction. So when you start going through the larger list, and again, we've done this for 10 or 20, 30 different companies on this list of the top violators, what we've found anecdotally is about 60 to 70% of all the companies on the list we can confirm either from personal knowledge, from public knowledge, or otherwise have had an FTC investigation. The remaining 30 or 40%, those are of companies that are under the FTC's jurisdiction. There is a quantity of companies here that the FTC gets complained about all the time, but they are outside of the FTC's jurisdiction. FTC cannot initiate an investigation. Banks are one of those. There, on the flip side, the other 30 or 40% that are under FTC jurisdiction but never get an investigation that we know about, the question is, were they investigated in a closed, confidential way that resulted in no action? And that happens a lot, where an investigation closes, and when it closes, there's no public announcement that the investigation ever occurred. So I throw that out there to say, anecdotally from our vantage point, there's an extremely high correlation between being identified over time as a top violator and then having an FTC investigation. We suspect the correlation is even higher than we can confirm based on the fact that there are probably a number of companies that have been investigated, but the investigation closed with no action. So let's go on to the next page.
David, I just wanted to add one of the, ironically, or maybe great opportunity here is we actually have one of our attendees is with Publishers Clearinghouse, and he pointed out that I think it's a great example of collaboration is that actually they worked with the FTC and related to that specific issue. With the data, with the issue as well, to both educate consumers and identify, the people who are behind it, and go after them. So, this is a, good collaboration opportunity, and great that that the FTC can work with companies to help shut down some of these issues. So, I just
absolutely,
want to point that out.
Point. It's a great point, and part of this goes, and we're going to talk about this a little bit more of how companies should be thinking about using the data. Part of it is knowing whether or not you're on the FTC's radar. But the other part of it is, as that comment illustrates, there's a lot of ways that companies can use this information proactively to help consumers. And one of them is if there is a problem, if somebody's impersonating you, absolutely. Knowing that fact, either because the FTC brings it to you, if you've risen to that level, but even if you haven't risen to that level, knowing that fact so you can bring it to the FTC, bring it to the public, bring it to the media, to basically defend yourself, defend your reputation because somebody's defaming you is extremely important. There's other ways to look at this as well. From a compliance standpoint, what we see sometimes is consumers filing complaints about things that the company never knew about because it's happening in a division or happening in a territory or happening in a franchise or something that the company may not have visibility into. But getting that feedback is very important so then the company can look from a compliance standpoint on how to shut it down. We've also, oftentimes we'll look at an industry so that we know we are a good player in the industry, our client is a good player in the industry, or your company is a good player in the industry, but there are other members of the industry which may have exceedingly high complaint volumes, and that could have a very detrimental impact on your company. In many companies, in many industries, what is negative to the industry hurts everybody. And the last thing you want is for the public, for the FTC, for government regulators to view the industry as inherently problematic. So being able to identify those issues ahead of time and then work with the FTC or work with other regulators to address them, even when they don't relate to your own company, can be extremely valuable. But we'll talk about that a little bit more, and I think that's a great comment. If anybody else has experience either way with either this data or working with the FTC, I think it'd be really useful to share. So other ways in which the FTC could use the information. Complaints that are received directly by the FTC are coded, I mentioned before, and they talk about specific allegations. And if you do one more click, Scott, I think a graphic will appear. So one thing we do often is recommend that companies understand what their own profile is. So regardless of what your volume is, regardless if you're hitting the top violators report, what this shows is a profile perspective of a company, and this happened to be an FTC enforcement target that the data was pulled on. They had 109 complaints, so nothing that would have made them on the top violators report, or maybe the search report, depending on when those complaints came in. But what we often do is pull from the data to see, well, what is the data showing us? And what you can see here is a breakdown for the different areas that have been coded within the database. And why is this valuable? One is if the FTC pulls the profile on your company. So if your company makes the profile of the FTC for some other reason, the investigator goes into the database and they look at it, the easiest thing for them to do is to see how are these complaints coded. So they don't have to read through 109 complaints to see that canned spam here is 17%, almost 20% is another canned spam category as well when you add in the other canned spams of all the complaint volumes. That suggests a canned spam problem. You see here COPPA is 4%, which is not huge. It's actually 6% because there's 2 COPPA categories. That's not huge, but that suggests a COPPA problem. Most companies do not have any COPPA complaints, and so you can see very quickly a profile snapshot of areas that it's suggesting you may have compliance problems. Now, does that mean you actually have a COPPA problem? No. Does it mean you have a canned spam problem? No. But does it mean that to a regulator who is viewing this, that it's suggesting you do? Yes. And knowing that, I think, is vitally important. It's something that I think you can't ignore. You ignore at your own peril. And then figuring out what those issues are, why it's suggesting this, is part of the strategy to protecting companies. Next slide. So here's another way, and if you click one more time, Scott, another graphic will appear. Great. So here's another way that that suggests companies should be analyzed in data, and I'd suggest that the FTC probably is. This is, again, another enforcement target that the FTC did bring a case against. And this is looking at the complaints over time, so how they're fluctuating. Again, this company would not have gone on the top violators report. In no month did they get more than 20 complaints. They may have been on the search report, but probably not. Even their swing is under 20 per month. But I can tell you for this company that the FTC announced the investigation in October of 2012. And you can see right after the announcement of the investigation, the complaint volume basically goes down to 0. And I'd suggest that might be because they stopped whatever practice was generating the complaints. But going back to the timelines before, if the FTC announces the complaint in October 2012, typically that means the FTC started its investigation about 12 months earlier. So if you go to October 2011, you see that is at the apex of their complaint volume. Now, again, looking at this in retrospect, I would suggest that had the company been monitoring its complaint volumes, it might have seen that it had an issue, which was rising over time. And when they started hitting new levels of complaint volumes, it might have been a good idea to evaluate whether or not there should be any remediation or whether or not there might be a compliance issue that the legal department was not aware of or that management wasn't aware of. And as I put in the notes here, it's no secret who this company is. I mean, this is MySpace. And I think it's very telling in terms of the complaint volume to see the trend over time, to see if there are any spikes. And if you go to the next slide, Scott, you'll see one more example of this. So this is a really dramatic example. On the left-hand side are the complaints received every month. On the right-hand side is the total number of complaints. This company had 0, basically, a very minimal level of complaints over time. September 2011, it starts spiking, and it goes up and up and up. What this would suggest to me if I saw this graph is something changed within the company that is causing a huge amount of visibility compared to where you were before to regulators. Does not mean that there's been a law violation at all, but it is something that I think from a management standpoint you absolutely want to be aware of, because your risk profile has dramatically changed. You were going from a risk profile where you were basically invisible to regulators to a risk profile where you had a significant amount of visibility. You may have been on that surge report because of the amount of delta that was happening every month. And so I would suggest that the appropriate way to view this is what can you do within the company when you see something like that to either accept the risk and understand it, or to examine your procedures to see if there might be something out of sync. Next slide. So I like this one. I threw this one in here. I talked before about not just understanding what your volume is, but understanding what others in the industry are. So this is a study we did several years ago about 6 different companies in a particular industry. And you can see that this has been broken down by month, by state, for each 6 companies. So the blue is one company, the green is another company, red. And what this shows is an interesting case study of an industry. In certain states, every player in the industry is getting about the same volume. In other states, and if you look at California, I know it's hard to see in here, one player in the industry was getting a volume that's 10 times larger than everybody else. It would suggest from a regulator standpoint, if you're the FTC, a distribution problem in that state for that player. That might be very important to the state of California, the Attorney General of California. It might be very important to the FTC. And this is something that I'd suggest is important to all of the different players in the industry. If there's behavior that might be negatively impacting consumers in California that might be attributed more than to just that one player, it's something that you might want to address informally with your competitors. It's something you might want to address with regulators about your competitor to make very clear that whatever issue is happening is being caused by another company, not being caused by your company. You can see the same thing happen with a different company in Minnesota. So a lot of interesting data when you start looking at it from a cross-sectional analysis over time or by geographic area. Next slide. So what are the practical takeaways? And I put for in-house counsel, but this is really just for management. So one thing is self-monitoring. The vast majority of companies don't track the quantity of complaints that appear in the FTC's database. It's just a fact. Companies that are more sophisticated and I think are really focused on quantitative ways to mitigate risk absolutely do. And it's something that we do for our clients. Some clients have us do it every month, where we track the complaint volume every month. Some clients have us do retrospectives, where we look at the complaint volume over the past 5 years in order to look from a holistic viewpoint of everything that a regulator would be able to see. So it's something that I would consider absolutely for any company that is concerned about the FTC, so that you know what the FTC knows. I put here, do the complaints filed against your company suggest a legal compliance issue? So step 1 is knowing if you have a problem, right? Step 2 is knowing if it's a real problem. If you have high visibility to the FTC, it means you have a higher risk of getting an investigation. It doesn't necessarily mean that you would lose the investigation. So the next step that I would take is if you have something that indicates you have this visibility, analyzing those complaints, going in and reading them, and seeing what would a regulator walk away from. If it's something like Publishers Clearinghouse, where a regulator would walk away and say, Publishers Clearinghouse is the victim, they are not in any way doing anything wrong, that's great information for you to have. It's information you may want to use in talking to regulators about how to protect your company as a victim. And then the other thing here is, if an FTC investigation were initiated, knowing what your complaint volume is means you know what they have. If you know what they have, it allows you to get ahead of the ball in terms of explaining the volume and the patterns and the trends. So if a FTC investigated you because of imposter fraud and they came to you, you could easily say, this isn't us. We've already been looking into it. We're very concerned about it. We have ideas of who this might be, but really don't spend your time, regulator, suing us or making us go through hurdles. Rather, spend your time protecting consumers by addressing the real people who are behind this. Next slide. What else? So evaluating your level of risk. The 2 reports I put there are the 2 that we know that the FTC uses. So besides the fact that any attorney at the FTC could use the data to look at a profile of a company, we know those reports come out every month. And one thing for all of our clients that we like to encourage them to do is to know whether or not their complaint volume is high enough to put them on the top violators report or to put them on the surge report. Because if it is, that changes the quantum of risk. One once you're on those reports, I counsel my clients that you are being evaluated by the FTC. Whether it turns into anything or not, you are being evaluated by the FTC. And so knowing whether or not you are likely on this list is a huge advantage. Next slide. And then the other takeaway is benchmarking. As I mentioned before, this is something we do very often, which is looking at other competitors in the industry to see where you stand up. No company wants to be the company with the most complaints in their industry. Every company wants to be the one with the least complaints in the industry or somewhere in the middle of the pack, because it suggests to a regulator that you are either the top violator, potential violator, or you have something consistent with what you would naturally expect. Next page. And then I put here, besides competitors, for a lot of our clients, we look at complaint volumes of business partners or service providers, or sometimes the clients, B2B clients. And the reason is, if they have an FTC investigation, that may have an adverse negative impact on you. So for example, if you were a payment processor and you have clients who are processing payments, absolutely, if one of those clients is on the top violators report for the FTC and may have an asset freeze against them that may impact you if they go out of business, that's information you'd want to know and you'd want to get ahead of. So it's something very common that our clients ask us to take a look at. So with that, let me talk a little bit more, and I think that's the end of the slides, and I'm happy to open this up to more questions, but let me talk about other ways that the government uses it besides what we've already talked about. So I've mentioned the formal reports that get created within the FTC and shared. And I've also mentioned, although I haven't talked about it extensively, that individual attorneys at the FTC can look up any company. They can type into a database and say, Acme, I want to see every complaint, and it spits out all the complaints. They can review them or they can analyze them. It goes a lot more broad than that. So the FTC opened up access to this database, online, real-time access, to any law enforcement agency. And they have literally had thousands of law enforcement agencies and individual members apply for access and receive access to it. So you can assume every state attorney general's office, most local, whether it's the Dallas PD or the Denver PD, have access to Consumer Sentinel. If they are going to investigate your company, a lot of them will use this and they will log in and do the same type of analysis we were looking at. So the assumption from the government standpoint is this is not just the FTC tracking you. It happens to be that the FTC owns the database. They are the host. But they have made it so that any government agency, any law enforcement agency can use that data to do the exact same things and analyze your company and the type of complaints that have been filed against your company.
David?
Yeah.
I'm sorry, it's Scott. I was going to add something to that. Back when I was a federal prosecutor, I had access to that database, and we used it pretty regularly. We would tap into it. But one of the interesting things we used it for was when we were looking at companies that were being targeted for phishing, and we would look into the database and see who are the top kind of complaints involving phishing. And then that would help. Oftentimes we would even be able to reach out to people, get the emails, and that helped us put together cases. So certainly at Justice, they were using this data as well.
Yeah, and I think that's a really great point, Scott. And the insight into what they were doing at Justice, I think, is really valuable. I mean, there's two other components, and I don't know if these were active at the time that you were at Justice, but what you see if you are a prosecutor or if you're a law enforcement agency is something like a Google search engine. You can filter, you can do searches, you can do it on different parameters, but you can also set alerts, and this is important. So if let's say that you are in the New York Attorney General's office and you're looking up Acme Corporation because you're thinking of bringing a case against them for telemarketing or data security or advertising, you can set an alert so that the system emails you every single time a complaint is added to the database from any source about Acme. More than that, you can also set a flag so that any other prosecutor or law enforcement agency that also searches for Acme knows that you're looking at Acme. So it becomes a tool, it can become a tool where law enforcement agents basically collaborate and figure out and coordinate their cases through this data, because if the Oregon Attorney General then logs in, searches Acme Corporation, they see a flag that has the name of the person from the New York Attorney General's, and I guarantee you in 5 minutes they're both on the telephone talking about their respective investigations and trying to coordinate it. So there's a lot of use that this is getting on the law enforcement side that it's important for companies to understand. A lot of times, and this is true for attorneys who even practice in this space, when they get an investigation from an Attorney General's office or from the FTC, they're just not sure where it came from. It's kind of a mystery. It's a black box. And one of the takeaways from this, I hope, is that people realize it is far less of a black box than you think. There are standard ways that law enforcement goes about investigating companies, and you should assume that these are happening. And what we do for all of our clients is take steps if we do get an investigation so that we get the same amount of information that they probably have, so that we're on equal footing. So with that, let me turn it over to any other questions. Scott?
Yeah, thanks, David. That was fantastic. I think we had a question a little bit. I held back on a little bit earlier, and I think you addressed it, which is you're getting the data through access through through Sentinel. Is that how do you gain access to the Sentinel data? Do you have to pay for it? Is it some kind of sign up? And I assume that's off of the FTC website.
So from a perspective for us, we gain access through Freedom of Information Act requests, and we've been doing this for a very long time. So we have a system that kind of streamlines it for us in terms of how we process the data and how we submit the request and how we get it back. But that's how companies go about obtaining it, which means it's not real-time access. So law enforcement, they get access to the database by applying to get login credentials. Once they have it, they have real-time access, and they can access anything they want on their computer screen. For us, through a Freedom of Information Act request, it means we have a 20 to 30-day delay in terms of getting access to the data, which is not problematic. It's just something to recognize that there is a lead time. And how we do this from a compliance standpoint for our clients, it's really for companies that are interested in either proactively seeing their visibility with regulators or interested in externally auditing themselves for compliance, and realize that it's a process, not a click the button type of activity, but something that will typically take between 20 days and 45 days to get the data, to analyze it, to understand what it means, and then to take steps from that. That makes sense.
And I have another question in particular about I think you showed the top violators report and the surge reports. How do you obtain those?
It's an interesting question. So I put two examples in there. Since those examples, and we got those from the FTC through FOIA requests, the FTC has refused to give us additional samples, additional documents, saying that it's interfering with their government investigations. So at this point, what I can say is we have a fairly good sense, in our opinion, of which companies would likely be on the search report or on the top violators report from our experience in looking at different companies, their complaint volumes. That being said, we don't right now have access to ongoing top violators reports or search reports. It's something I hope that the FTC will change its mind on. I think there's a really good public reason for those reports to be made available. I think it allows companies that are on there inadvertently to realize that and take steps if there is a compliance problem to fix it. It also allows companies, like what we've already heard from Publishers Clearinghouse, that are on it through no fault of their own, but because somebody else is attacking them, is victimizing them, to take steps to protect themselves. So I think both of those make really good sense for more broad disclosure. But it's something that, right now I know the FTC is considering, but their current position is that it would interfere with their government investigations for that information to get out.
Great. Well, that is actually all the questions I have. It's been a great presentation. Thank you again, David. Just so everybody knows, this presentation was recorded and it will be available online at the Online Trust Alliance website, or at least through it. Again, thank you on behalf of the Online Trust Alliance. As you know, our mission is to enhance online trust, promote innovation and the vitality of the internet. We really appreciate your presentation, David. We appreciate everybody attending, and that will wrap this one up for us. Thanks all.